with Jeff Van Tress, an attorney with many years of legal experience. He will discuss patent law, civil litigation, and contracts with a special interest on elder law. This needed information is meant to clear all questions you may have in this area of interest. Today's show is brought to you by Fresh Start Tax Services. Get a fresh start on doing your taxes right. Fresh Start Tax Services, and by the law firm of Alton, Flynn, and Kubler, specialists in intellectual property and elder law. Visit them today. Have a legal question or something legal on your mind? Call 888-565-1470 and talk to Jeff Van Tress. And now, here's Jeff.
Good evening, South Florida. My name's Jeff Van Triese, and welcome to the very first episode of my show, Talk Legal. This show will be discussing legal topics in a variety of fields, and each week I'll be bringing on guests to discuss a variety of topics and how the law affects our society and our lives. A little bit about myself. I'm an attorney. I practice intellectual property law, including patents, trademarks, and copyrights, as well as elder law. My very first guest this week is a friend of mine, Evan Rosenberg. He's an attorney with a lot of experience in criminal law, and he's here today to discuss the rights that we as citizens have and what to do in the event that you're stopped by the police or in the event that you're arrested. So, Evan, welcome to the show, and thank you for being my very first guest.
Thank you for having me. I'm excited.
Great. So, I'm sure you've had a lot of clients over the years that have had issues with regard to searches and seizures and whether certain evidence is going to be allowed in, and that's always a critical aspect of a lot of cases that you may have in the criminal arena. So, if just basically, if you could just discuss what is a warrant, what is the warrant requirement, and when does that come into play in a criminal case?
Well, before we get into that, you make a good point. Search and seizure. My job is as a criminal defense attorney is based off of three things: Fourth, Fifth, and Sixth Amendment.
Right.
Now, the warrant requirement falls under the Fourth Amendment, which is the search and seizure. Fourth Amendment to the Constitution.
Just for clarity, why don't we just identify what the Fifth and Sixth Amendment are?
Sure.
Sure.
Well, the Fourth Amendment talks about, and I'll read word for word what the Fourth Amendment is. The Fourth Amendment states that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describe the place to be searched and the persons or things to be seized. Now, it really doesn't go into what happens when you get pulled over by a police officer,
right,
or when a police officer searches your vehicle. It's very vague, but the case law over time has evolved into a way that interprets the Fourth Amendment to mean certain things, and there are certain cases, landmark cases that have evolved over time that has allowed us to argue certain things with regards to the Fourth Amendment. So the Fourth Amendment, we call it the Search and Seizure Amendment. Now, with regards to a warrant, is based off of one primary thing, is probable cause.
Well, let's just say, what is a warrant? Let's just identify what it is. We all probably have some idea, just based on watching TV and so forth, when a warrant is required. But what is a warrant? What's on it, and what does it allow the police to do?
Well, the best way to describe it is to talk about the process. Police will do their investigation based upon either a tip or observed activity, and they may come into information where, hey, I need to get into this house because I see people coming and going in all hours of the night. Could be a drug house, and they develop their investigation. And what they do, they take that information and they type up a narrative, and they bring that narrative to a judge. Typically, there's a duty judge in each county, and the judge will review the narrative and find whether or not there is enough information to establish probable cause in order to allow an officer to go in and search the residence or the structure.
Great. And probable cause does not necessarily mean probable, in the sense that somebody's probably guilty. It simply means, and you can clarify this, that there's enough evidence available that would lead a reasonable person to think that the suspect in question.
And the key is reasonableness.
Reasonableness.
Right. Whether or not a reasonable person or a police officer believes that a crime has been committed, is in the process of being committed, or has been committed.
Right. And there's no way to define that mathematically. It's not 50%, 60%. There is no way to put that into numbers. It's just
in the eyes of the beholder.
In the eye of the beholder.
Right.
Which in this case will be the judge.
Right.
Right. So in the event that you are searched in a manner that the police are supposed to get a warrant and they don't, or there might be some exceptions. For example, there are exceptions to the warrant requirement where the police don't necessarily need a warrant.
Right, and we're talking about a warrant in terms of a search.
Yes.
And there are situations where police officers don't need a warrant. One of those is consent. A police officer knocks on your door, your house, and say, "Hey, can we come in? Can we look around? Can we search your house?" Obviously, there's no warrant requirement if you freely and voluntarily let them into your house and say, "Hey, yeah, go ahead and look."
Right.
So that's one exception. The other exception is a search incident to arrest.
Right.
What that means is, let's say someone is arrested independently of any information as far as a search. For example, let's say someone's pulled over, arrested for driving with a suspended license.
Right.
At that point, the officer has made the arrest. They've identified that the person doesn't have a license. At that point, since they're arrested, the officers can then do a search, an in-depth search of the person's person, I guess you could say.
Yes, the person's body, right?
The person's body.
And anything attached to their body.
Right, and the rationale behind that is for officer safety. You know, that if the person's being brought to a jail facility, they don't want to have them come in with any sort of contraband. So if there's an arrest that occurred, search incident to arrest, you don't need a warrant.
And of course, it's very important with the search incident to a lawful arrest that the purpose of the search is for officer safety. Now, if they happen to find something, contraband or evidence that a crime's been committed while they're searching somebody, then that can potentially be admitted so long as the search itself is only being done for officer safety. Is that correct? Not
only could it be admitted, but it could be new charges. Let's say during that search, going back to my original scenario, let's say that there was the search of the person arrested for driving with a suspended license, and they search the person's body and discover a bag of drugs, cocaine, marijuana, what have you. At that point, then they can also charge them accordingly with whatever's found as a result of that search.
So in a situation like that, you may have a situation, we're going to talk about Miranda in a minute, the Miranda warning, but you may have a situation with a search incident to lawful arrest exception to the warrant requirement where a person's arrested and charged with a crime. Not only has that person not been given a warrant, or there is no warrant, but on top of that, they haven't even been read their Miranda rights necessarily. And so before any of those things have happened, the evidence against them has already been seized.
Yeah, and it's funny you talk about Miranda, because that's the one thing I get often with clients. They ask me, or they tell me, look, police officers never read me my rights. They think, oh, great, jackpot.
Exactly, right.
Case dismissed. They didn't read me my rights. Unfortunately, I have to break the news to them that it doesn't work that way. My follow-up question to them is, well, did you make any statements or admissions to them? And typically the answer is, well, no. In that case, they don't need to read you Miranda. But I guess we'll.
Well, why don't we talk about when Miranda is required? Miranda that was a Supreme Court decision in the 1960s, and it involved putting suspects that are arrested on notice of what their constitutional rights are, mainly their right to remain silent. Now, this is not always required. They don't always have to read Miranda rights when anybody's arrested. It's only under certain conditions, specifically custodial interrogation.
Absolutely.
Which if you could tell me about the requirements of custodial interrogation, because both of those, you have to be both in custody and being interrogated.
Right.
So if you could maybe talk a little bit about that and when situations are might be a close call as to whether Miranda is required or not.
Yeah, it's interesting. You're absolutely right. The two requirements in Miranda is custody and interrogation. What a court typically looks at as far as the custody aspect is whether or not the police deprive you of your freedom of action in a significant way. Now, realistically, what that means is arrest. An officer typically won't read you Miranda until the arrest has been effectuated. There have been arguments. There is case law out there that.
Why don't we define case law?
Good point.
Case law is decisions made from judges that are binding on lower courts. That is decisions from higher courts that are binding on lower courts that interpret the Constitution or other laws. So when you say case law, you're saying decisions from the Supreme Court or other courts that say what is required and what is not.
Mandatory or persuasive upon the court that's hearing the
case.
On
the trial court.
Correct.
Right, exactly.
And there is case law out there that applies to certain situations. If a person's taken out of their vehicle and handcuffed, and the officer says that, well, I'm just detaining you. There's case law that says, look, you're in handcuffs. One could reasonably believe that they're arrested at that point in time, so Miranda would apply. So there are certain situations where what is arrest or what is police custody. Again, it varies based upon the case law. So it's not necessarily. What's the best way to put it?
It's not black and white.
No, it really isn't. It really isn't. Arrest is such a vague term. Is arrest when the person's in cuffs? Is the arrest where the person's in cuffs in the back of a vehicle? Is arrest when the person is told, sit on the ground, wait while I'm doing my investigation? It's not a black and white issue. There is case law out there that kind of as defense attorneys use to bolster our case.
And getting back to your the issue about search incident to a lawful arrest, that is when the police officer can search your vehicle or yourself when they're arresting you for their officer's safety to make sure you don't have weapons on you. They can put you in the back of a police car and then search your car. Even though if you have any weapons in your car, you couldn't get to them because you're in the police car, they can still search your car.
Right.
Keeping in mind that at this point there may have been there's no warrant and possibly no Miranda have been read at this point. So this really illustrates that there are very wide exceptions to the Miranda rule and very wide exceptions to the warrant requirement.
Yeah, the automobile exception is one of them.
Right.
We didn't get to talk about that. Yeah, the automobile exception is one of the exceptions to the warrant requirement. The driver or the arrestee is where the person is within reaching distance of the passenger compartment at the time of the search. An officer doesn't need a warrant in that specific situation, or if it's reasonable to believe that the vehicle contains evidence of the offense of the arrest, meaning the police can't search your car for a weapon unless the arrest is for a violent crime or an illegal possession of the weapon.
Right. So in the event that you are stopped by the police and it's not really clear whether you're free to leave, what should you do at that point? Are you free to leave? If a police officer comes up to you and starts asking you questions, are you free to go?
Well, if it's a traffic stop, at that point the officer has probable cause based upon some sort of traffic violation. So at that point, you can ask the officer if I'm free to leave, but I guarantee the officer is going to say, no, I'm writing you a citation for speeding or whatever. So at that point, you're not free to leave. But if it's a situation where you're walking along the street, an officer comes up to you and starts talking to you, you can ask them, look, am I free to leave? And if the officer says, yes, you're free to leave. Sometimes they may not be as forthcoming with whether or not you're free to leave. And that's where, if that situation does occur, make sure you reiterate, am I free to leave? Am I free to leave? Now, don't just leave willy-nilly without them confirming you're free to leave, because then you may have other legal ramifications on your hands. But the best thing to do when you're approached by a law enforcement officer and you don't want to talk to them, just verify. Look, am I free to leave? Am I free to go?
Right.
Are you detaining me, or am I free to go?
I'm sure this probably comes up with people that are suspected of shoplifting, and that can even lead to civil litigation for
Absolutely
wrongful arrest. We're going to be talking about some current events when we come back from break, but at this time we're going to take a few minutes to talk to our sponsors, or hear from our sponsors.
The law firm of Alton, Flynn, and Kugler specialize in intellectual property, copyrights, trademarks, and elder law. They also deal with patent law, so if you have an invention and would like to patent your idea, give them a call at 954-563-4814. That's 954-563-4814. They offer elder law services including estate planning, long-term planning, and preparation of healthcare documents. They strive to plan for your future needs while allowing you to retain as much dignity and independence as possible. To find out more or to make an appointment, call 954-563-4814 or visit them at altmanpatent.com. This program is brought to you by Fresh Start Tax. Fresh Start Tax offers a full range of tax and accounting services, including tax return preparation and bookkeeping, as well as back taxes, wage garnishments, unfiled returns, or any other tax-related concern. Our dedicated team of tax attorneys, CPAs, and former IRS agents offers 60 years of professional tax experience. For a free consultation, call 866-700-1040. That's 866-700-1040. You can also visit us on the web at freshstarttax.com. You're listening to Legal Talk with Jeff Van Tress, who brings all the latest news in the legal world. If you'd like to ask a question on the air, call 888-565-1470, and your question will be heard on the air. That's 888-565-1470. Now, back to our show.
And we're back. This is Jeff Van Triese from Talk Legal. I'm joined by my guest, Evan Rosenberg, an experienced criminal law attorney. We've been talking about constitutional rights as it relates to searches and seizures, Miranda warnings, and a number of other issues. But we're going to switch gears a little bit now and talk about some current events. Recently in the news, NFL player Adrian Peterson has been accused of child abuse, and that's an issue that Evan has dealt with several of his clients. And I was surprised to learn upon some further research how amorphous the standard is for determining what is abuse and what is not abuse, and as far as how corporal punishment is defined. So turning to Evan here, what is corporal punishment? How is it defined legally, and how do you define the line between rearing a child through the use of corporal punishment and abuse? Where is that line drawn?
It's interesting you say that. There is no statutory definition.
Statutory or case law, as you said earlier.
Well,
right?
Florida adopts what's called the common law
Right.
definition of corporal punishment. Corporal punishment is essentially a way in which, or a defense to child abuse where an individual uses certain means to discipline their child that may involve hitting, spanking, or some sort of violent act, I guess you can say,
Right.
For lack of a better term, violent act. Corporal punishment is a defense to child abuse. Now, many states have banned the practice of this, but Florida is not one of them. Florida allows for the use of corporal punishment.
So you're allowed to hit your child, essentially.
Well, it's funny that you say that, because it really comes down to what we said before. It's really in the eye of the beholder. In this particular case, it'd be the jury, whether or not they think it's reasonable. The limits of the parental privilege, it's not very easily defined, but are on a case by case basis. And what the jury has to look at is whether or not the what was inflicted was reasonable under the circumstances, and that's what a jury is left with, whether or not what was done is reasonable under the circumstances. And it really comes down to a question of the jury makeup,
right?
Whether or not the jury believes that it's reasonable under the circumstances. Some jurors may have grown up having that done to them and think that may be reasonable, a reasonable way to discipline your child. Others may not, who grew up in a household where it wasn't very common. So reasonableness really depends on the jury makeup because it's a cultural thing. So a defense attorney, is going to try to do his best to try to tailor his jury around those who believe or would be open to the concept of corporal punishment as a defense to child abuse.
So essentially, that sort of proves the old adage that trials are won and lost at jury selection.
Very much so.
And really, it's not a question of whether abuse occurred objectively. It's a question of whether these 6 jurors find the conduct acceptable.
Absolutely.
And so we've often heard, that the critical question with child abuse is whether there's been a mark left on the child's body, and that's not exactly the case in Florida. That's not the threshold question. The question is whether, under the circumstances, the conduct of the parent or caregiver of the child is reasonable with corporal punishment. So where do you see this case going? With the Peterson case, there seems to be some information coming in that he may have hit his child with a switch or a tree branch or something to that effect, and caused some injuries to his child. Where do you see this going? Do you think it's just totally about whoever's on the jury in a situation like that, if you were to have a case like that?
Well, it's tough to say. I think if we put it in context of if this happened in Florida,
in Florida, right?
Yeah. If this happened in Florida, it really is going to come down to the jury makeup. The jury is balancing whether or not it was reasonable under the circumstances with the definition of child abuse under 827.03.
That's the statute. That's the child abuse statute under Florida law.
And I want to quote the statute real quick because I think it's interesting how it's an interesting paradox between the defense of reasonableness under the circumstances in terms of corporal punishment as opposed to the definition of child abuse under the statute. And what it is an intentional infliction of physical or mental injury upon a child, an intentional act that could reasonably be expected to result in physical or mental injury to a child, or active encouragement of any person to commit an act that results or could reasonably be expected to result in physical or mental injury to a child. Very broad definition.
Right.
Very broad definition. So, a jury's got to look at whether or not there's been intentional infliction, physical infliction.
And of course, mental infliction especially is going to vary from child to child. You may have children that have developmental disabilities that might have a different threshold for what can happen to them as opposed to a child with normal developmental range. So you might have very extremely broad scope of what constitutes mental injury from this abuse.
And a savvy prosecutor, could go into trial saying, look, if we haven't proven the physical aspect of it, we can try to prove the mental aspect. So it almost gives them another opportunity to prove their case, that they can try to play on the emotions of the jury and, try to say, look at the possible mental anguish that it's caused.
Right. So that's an issue that certainly our courts will be continuing to grapple with, and the need for criminal attorneys will be great in that area. Moving on, last week there was a shooting, a tragedy in St. Louis with respect to a young man that was shot by at this point an unidentified police officer while he was walking on the street. It appears as though we don't have all the information with regard to that case, but it appears as though the officer in this question was off duty, was working for a private security was working as a private security guard. In a situation like that, what do you have to do if you're stopped by an officer that's off duty? How is that different than being stopped by an officer that's on duty?
I would make the argument that an off-duty officer is a citizen like you and me, and in Florida, like many other states, allows for citizen arrest. Now, citizen arrest can occur where it's been a felony that occurred in the presence of a person. Then a person can make a citizen's arrest. You can chase down someone you saw snatch a woman's purse, or take down someone you see violently hurting someone. But you can't pull somebody over for speeding, or someone who ran through a traffic light. And you can't arrest someone for a misdemeanor shoplifting. So it's got to be something that's a felony that's committed in their presence.
Right, looks like we are running out of time here. Evan, thank you so much for being on the program, and we hope to see everyone next week at 6 o'clock. Thank you so much.
Thank you for listening to Legal Talk with Jeff Van Triese. Tune in again next week for more exciting information about the many different sections of the law. The content of the preceding program, including all statements from the host and guests, is to provide general information and commentary about the law. Under no circumstances does any statement made by a host or guest to a caller or listener constitute legal advice or the information of attorney-client relationship. And the material from the program should not be viewed as a substitute for personal consultation with an attorney. The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and